So you may have seen by now that MP, Mike Amesbury, his appeal was heard today, and his sentence was adjusted. Originally he had 10 weeks imprisonment, but at the appeal that has now been suspended for 2 years. So he gets to walk out of prison after spending 3 nights there. So that raises the questions which a lot of people have asked, especially on the back of Dan's just done a video about this as well. And if you want sort of more background detail about the technical stuff, definitely go see Dan's video. But the 2 questions are, first of all, how did his appeal get on so quickly? And secondly, is that sentence correct? I mean, has he been let off? To cut to the chase, the answers to those questions are, well, not really in terms of the speediness of the appeal. As to whether it's a let off, that's more sort of, So let's investigate the issues. First of all, the appeal itself, how did that happen? Well, at the magistrates' court, he pleaded guilty to a charge of common assault. That case was heard in front of what we now call a district judge, the old stipendiary magistrates. When you go to the magistrates' court, the bench can either be 3 laypersons, so that's just 3 local members of the community, and they are guided in the law by the legal advisor, what we used to call the court clerk, and indeed what some of us still do. I always still say your learned court clerk. We keep getting told off for saying learned, but I just think it's polite. But this was a district judge, so that's a paid magistrate, and they are legally qualified, so they don't need a legal advisor. And the magistrate, after considering all the factors, he imposed a sentence of 10 weeks imprisonment. And that's well within the sentencing guidelines for an offence of common assault. But what is common assault? Common assault is actually, it's putting somebody in fear. Putting somebody in apprehension of the immediate use of unlawful force. So you don't actually have to hit somebody or connect with them. Any touching, non-consensual touching, that can be an assault. There's no sort of requirement that causes any harm, but you can assault somebody merely by being scary. So if, for instance, you go up to somebody and go, "Rrr," and they think, oh, something might kick off, that is an assault. You can't commit an assault by words alone though, so saying something like, I'm going to do you, isn't an assault. Interestingly, you can negate an assault through words though. The classic case on that was somebody, they were having a row with somebody and they drew their sword. Shoo. But they said, were it not a size time, I would run you through. And they were prosecuted for assault, because obviously somebody waving a big sword at you, it's not unreasonable to be worried about that. But they said, no, his words made it clear that he wasn't actually going to run you through because he was worried about being prosecuted. So that negated the assault. But when there's actually contact, we sometimes call that a battery. I mean, you may remember the old, assault and battery. But technically speaking, well, all batteries are assaults, not all assaults involve battery. But in this particular case, this is what we call an assault by beating. He laid hands on somebody. So a 10-week sentence was perfectly within the guidelines, even on a guilty plea. But then he appealed. Now, you can appeal either a conviction or a sentence from the magistrates' court. So say, for instance, you plead not guilty and you are convicted, you can appeal. But also, if you plead guilty, but you think the sentence is too high, you can also appeal. And unlike most appeals, this is an appeal as of right. You don't have to get leave or permission to appeal, and you don't have to show any grounds of appeal. Interestingly though, the form, when you put in the appeal form, it does actually ask you to list the grounds. And back in my criminal law days, I used to just write, didn't like a result, because you get the appeal anyway. And also, unlike most appeals, where you can only succeed on appeal if the appeal court says the lower court got something so wrong no reasonable court could have made that decision. It's actually what we call a de novo hearing. It starts from scratch. Because appeals are very hard to succeed on normally, because it doesn't matter that the appeal court might say, well, we would have actually come to a different conclusion. But unless the original judge's conclusion was so off the wall that no reasonable judge could have done it, they can't put their own, they can't supersede the judge and say, we now actually put our own decision in place. They can't overrule that unless it's effectively a perverse decision. But when it comes to an appeal from the Magistrates Court to the Crown Court, then it all starts from scratch. If you're appealing against conviction, you effectively have a re-trial and a re-hearing. And they can, the court can come to whatever conclusion it wants to. Similarly with an appeal against sentence only, which is what this is. Who makes the decision? Well, in the Crown Court, it's a Crown Court judge and 2 lay magistrates. They decide. And interestingly, they've all got an equal vote on it. The judge will advise them as to the law, but when it comes to deciding, what the decision is, it's an equal vote. So theoretically, it could be 2-1, and it could be the judge who disagreed. But if the 2 lay magistrates say, well, we think this conviction should be upheld, or this conviction should fail, or this sentence is too high, or this sentence is too low, it's just a simple majority. I mean, normally though they will come back unanimously. But the judge doesn't have any special treatment there. So like I say, the 2 lay magistrates can overrule them. But this appeal came on very quickly. Is that unusual? No, it's not actually. Where somebody gets a short custodial sentence, then obviously, if the appeal's going to not be heard until after they've served the sentence, it all becomes a bit of a nullity, to sort of say, congratulations, actually, you were falsely convicted, or you were sentenced to too much, so we acknowledge that, but tough, you've already done it. So appeals for short sentences come on very quickly. I mean, if it was just a fine, or even community service, then there might not be such an urgency about it. Also, you can apply for bail pending you say, I've got an appeal coming on, I'd like bail pending the appeal. But generally speaking, it's quite hard to get bail. It's the same with anything. The mere fact that you are appealing something, we say it doesn't act as a stay, whether that's in civil or criminal. So the mere fact you're saying, say you're losing a civil case, you say, we want to appeal this, so can we not pay the money until after the appeal? It's like, well, no, the judgment stands, and if you are successful on appeal, then they'll overrule that, and you'll get your money back. And it's the same in criminal stuff. It's like the mere fact that you're appealing doesn't change the situation. It doesn't act as a stay. But like I say, you can apply for bail, but generally speaking, it's hard to get because, especially in this case, the district judge will no doubt have said, well, no, I think I got the sentence right, and I don't think an appeal will be successful, because if I thought the sentence might be wrong, I wouldn't have come to that conclusion. So it didn't grant bail, but that's why it was heard very, very quickly. I mean, they're supposed to come on within, because you've only got a very short time to lodge the appeal anyway. You've only got 12 working days to say, I want to appeal this. And they do try to get them on very, very quickly. And where it's just an appeal against sentence, I mean, this hearing lasted, probably like 20 minutes. So, they can get them on very quickly. So, as to, has he been treated any differently in how quickly the appeal came on? No, he hasn't. That's a very, very standard thing where people are serving short custodial sentences and they weren't granted bail. As to the sentence itself, now what I found interesting here is the judge said, why was this just charged as a common assault? Why was this not charged as an affray? Now, an affray is a type of public order offence, and the elements of affray are that you put a bystander, your actions would cause a bystander of reasonable firmness, not too timorous but not too brave, to again think that there was an immediate apprehension of unlawful violence. So if you see something kicking off in the street, I mean, if it's clearly just 2 people having a punch up and they're just sort of, doing it to themselves outside the kebab shop, arguably that's not an affray. But if you sort of see public disorder, like 2 people fighting, or even just 1 person sort of kicking off, and the test is, would somebody walking past go, oh, I'm not sure what's happening here, that, I might get dragged into this, or, I might be at risk. That's all you need for an affray. It doesn't actually matter if a person isn't present. It's just a hypothetical. So it would, if somebody was walking past at that time, or somebody was observing that, and again, like I say, not too brave but not too timorous, and they said, ooh, I'm not sure about this, I think I'd rather be somewhere else, that's the element of affray. So clearly, like a punch up in the street like this, they are quite often just charged as affrays, and you can actually charge them as common assault and affray. The common assault is your victim got hurt, but also, because it's a public order offence, you caused or potentially caused members of the public to worry as well. So that's why it's a public order offence. However, the judge said, I will not go behind the charging decision. And again, is that 2-tier justice or whatever you want to call it? Could the CPS have actually banged an affray on there? Well, they possibly could, but in all fairness, they got a plea to common assault. I mean, I don't know even if affray was sort of floated in the first place. It might well be. They said, we're going to do your guy for affray and common assault, but we'd take a plea to the common assault. I mean, that is a very common one. Because fundamentally, the the criminality, the culpability can be reflected in the sentence anyway. So it's like, well, you've been charged with common assault, but this was a very, very serious one. But like the judge said, he couldn't go beyond the common assault. He couldn't start saying, well, this should have been an affray, so I'll sentence you as if it wasn't an affray. So did he get lucky with just being charged with common assault? Well, the fact that he pleaded guilty, to be honest, if you are charged with affray and common assault and you offer a plea to common assault, chances are the CPS would accept it. So again, I don't think there's anything particularly two-tier there. But what about the sentence itself? Well, the judge and the magistrates in the appeal, they made a big point and said, we think this was absolutely spot on. We do not criticise the district judge's decision. This is clearly a sentence that could stand. However, because it is a de novo hearing and they can impose their own decision. I mean, theoretically, they could actually send it back to the magistrates court and say, well, we see you got the sentence wrong, but you go back and you re-sentence them. But usually, it's very rare for that to happen. They say, right, we'll impose our own sentence. So what they've done, they've suspended the sentence for 2 years. But they've also imposed 200 hours of community service, which is usually, if you get a suspended sentence, usually you will get some punitive element as well. I mean, that's what I found very unusual in the Hugh Edwards sentence, the fact that they gave the suspended sentence, but they didn't also say, well, you've got to do at least a bit of community service, because, otherwise there's no punitive element. But they said 200 hours community service. He said this was actually a very high-end one, so the starting point was 300 hours community service. However, I accept, there was the guilty plea, so you're not 1/3 off. What's the effect of a suspended sentence? Well, basically, for the next 2 years, if he commits any further offences, then not only will he be sentenced for the new offence, the original sentence must be, quote, activated in full, unless it would... oh, dogs! Hello, doggy! Oh, you can't see this because he's quite a tiny dog, but I always get distracted with dogs. But yeah, the sentence should be activated in full. Unless it would be unjust to do so. So not only do you get sentenced to the new thing, you also get the suspended sentence kicks in, and usually that would be consecutive. The new offence would be consecutive to that. But they don't have to impose the whole sentence, or indeed any of the sentence. They can sort of say, oh, well, go on then, we're going to let you off because of the unusual circumstances. Or they can say, well, we are going to activate the suspended sentence, but we're only going to activate like half of it or something like that. So he's got to keep his nose clean for the next 2 years. And he's also got to do his 200 hours of community service. He's also got to attend an anger management course, because the judge said, the problem here is, first of all, you were in drink, and also you clearly can't hold your temper. I mean, the judge was very critical of him because he said you told a tissue of lies to the police. Luckily, we had the video here to see what could be really went on. His defence counsel sort of hinted at suggesting there was some provocation, but very quickly withdrew from that. And I think that was very wise, because you've got to be very careful when you're sort of going, well, there's a bit of provocation. It's very easy to turn that into victim blaming, and judges do not like that. You're usually better off just apologising profusely, throwing yourself on the mercy of the court. But then, if there is an element of provocation, you can let the judge work that out for themselves. You don't have to sort of grab them by the nose. You can sort of say, well, obviously this guy was kicking off and this guy was threatening my guy, but we accept that's no excuse, and provocation, there was no and then the judge can say, well, actually, I do find he was provoked. However, provocation, it goes to mitigation. It's not a defence, except in certain cases of the M word, where indeed provocation can turn M. And people in the comments were wondering what it's M for. You remember dial M for, or if you've got a group of crows together. That's what we're talking about there. But provocation for the M word offence can actually reduce it to manslaughter. So it can be a partial defence. But here, where it's just common assault, it isn't. You're expected to just walk away from it. The fact that he was actually hitting the guy when he's on the ground, that is the thing. That's what usually crosses the custody threshold and says, right, you're going inside for that. Because to be honest, like a bit of argy-bargy outside a kebab shop, chances are nobody's going inside. But what the courts don't like is, kicking a man when he's down. I mean, certainly kicking will always get you inside, and kicking in the head will get you a very lengthy sentence. But punching somebody on the floor will also cross the custody threshold. And that's the thing with the suspended sentence. Before you do a suspended sentence, you have to say, well, is this an offence that would attract custody in the first place before we consider suspending it? So you can't sort of say, well, I think this could be a bit of community service, but I'm going to just make it a suspended sentence anyway. But, you know, it has to be something that you could go to prison for. It's also, because the judge expressed and said he was very disappointed that while Mr. Amesbury says he's reduced his drinking, he hasn't stopped drinking entirely. Because that came out in the pre-sentence report. So what he's also done, he's done an abstinence order for 12 months. So it's like he cannot now imbibe or consume alcohol for the next 12 months, and that can be randomly tested. And if he was to do that, that would be a breach of the suspended sentence. He's also got to attend 20 rehabilitation days, which he can do in the next 2 years. So it's basically got to do his anger management, but it's also got to just do general, we expect better from you. I mean, the judge sort of said, like, I'll keep it neutral. He said, I won't give you more because you're an MP. He said, clearly you did rely on the fact that you're an MP to hopefully get you out of this, but I'm not going to make it the sentence up. I'm going to treat you as a regular member of the public. However, I can take into account, so there's a bit of a contradiction here, the fact that you are a public official and you're in the public domain, and we expect better of our politicians. So I do think there's a bit of a contradiction there. But yeah, so that's the sentence. And like I say, it's well within the sentencing guidelines. There's nothing particularly controversial. Cases like this happen all the time, where you get immediate custody and then you go to court and you sort of grovel a little bit, and sometimes you can get it converted into a suspended sentence, not least now when the prisons are full to bursting. But they seem to have gone down the justifying on the rehabilitation element. It's like, well, you've clearly got an anger problem and you drink too much, so what we'll do is we'll treat you in the community. We'll make you do the anger management course, we'll ban you from drinking alcohol for 12 months, and we'll also get you to do these 20 days of hopefully getting you to think and be a bit smarter. So there you go. So that's in summary. So yeah, to be honest, it's a bit of a, like I say, I can see why it's controversial, and I can see why people have strong opinions on this, and I would love to hear all your comments about this, please, because I'm not bothered about the likes and subscribes, but I do like to read your comments, not least because A, they're interesting, but also they give me ideas for future videos, so thank you very much. But there you go. As always, hope you found that vaguely informative, vaguely accurate, vaguely useful. Where am I today? I'm back on Pentire, because it's not raining. I mean, I had that lovely day down at Kynance, that one day of nice weather, and literally the next day it was torrential rain. I was driving through floods everywhere. But as it appears to have eased off a little bit, I thought I'd run up here, even though I've got a trial tomorrow, although they haven't sent me the papers yet. So I'm just sat here going, Tum-ti-tum, please send me the papers at some stage before the trial. I'm sure they will, but this is all part of the fun of life at the bar.